So assuming there are no patents or trademarks, then you must decide what type of intellectual property to pursue. And people confuse the different types of intellectual property. I'll have people call and say, I would like to get a trademark on my idea or a patent on my name. Today we're going to talk about the differences between the different types of intellectual property. You have patents, trademarks, copyrights, and even trade secrets. And so we're going to clear up what these different types of intellectual property cover. So, as I mentioned, the forms of intellectual property include patents. They protect useful, novel, and non-obvious, and we'll get into that, processes, machine, manufacture, composition of matter, and improvements thereon. So basically anything under the sun. A lot of people come to me and say, is this patentable? Yes, it is, unless it's something that comes from nature or something, a mathematically abstract ideal or something. Almost anything is patentable. The question is it new? Has it been done before? And even if it hasn't been done before, is it non-obvious? And we'll talk about that. But pretty much anything under the sun can be patented. It's subject to be patented. The question is, does it meet the other requirements? Trademarks, on the other hand, protect symbols and characteristics, names of a product. Nike, things like that. That's what trademarks protect. It's that name association that people put to products that identify the source of a product. That's what a trademark is. The patent protects the product, the trademark protects the name, the packaging associated with that product. Trade secrets actually protect secret information. It's a little bit difficult to explain what a trade secret is, but a trade secret is anything that you keep secret. It's protected under the law. In fact, we talk about file a patent application to protect your idea, file a trademark application. With the trade secret, you actually don't file anything. It's protected because it is secret. And you have to maintain that secrecy. And if you can prove that you use reasonable security measures to keep it secret, the courts will give you that right. So you actually don't do anything, but you have to, in terms of registering your trade secret with someone, you actually simply go about your normal business using reasonable security measures to keep it secret. So for example, a customer list. If you're into sales and you've expended a lot of energy to build up a customer list, and you have sales reps and one of your sales reps decides to leave and they take your customer list with them, well, you have a cause of action against them for trade secret misappropriation. You didn't have to do anything to have that protection. The mere fact that you had that customer list, and if you use reasonable security measures to keep it secret, you have protection by that fact alone. And that is an actual form of intellectual property. If you're a business right now, you probably have lots of intellectual property in the form of trade secrets that you don't know of. And if you have employees that are leaving and going to your competitors or starting their own business, if they're taking trade secret information with them, that's something that you can protect against. So it is a form of intellectual property. And then copyright protection, it protects expressions, but not ideas. I had a client once come in and say, I filed a copyright on my idea, but that was the wrong thing to do. It only protects the expression of the idea. It doesn't protect the underlying idea. So she did the wrong thing. By filing a copyright, she actually disclosed her invention, but didn't protect it at all. The only thing she had protection on is the expression embodied in the written thing that she submitted to the Copyright Office. So it's very important that people understand the proper way to protect their intellectual property, because if they do it wrong, they actually can do more harm than good.